All right, we'll formally call this meeting to order of the Cannabis Compliance Board for September 22nd, 2020. We need to begin with our formal roll call.
Great, Chair, thank you. Member Jerry Merritt.
Here.
Member Dennis Nylander.
Here.
And Chairman Douglas.
Here.
Great. Deputy Bala, can you please confirm that we have complied with the open meeting law requirements?
We are, Director Klimas.
Great. Well, Chair, with your approval, I'll get started by introducing agenda item number 1.
Please go forward.
Fantastic. Agenda item number 1 is public comment. Ms. Bonner will now read into the record all public comment received up until the start time of the meeting. Any public comment received after the start of the meeting will be read into the record at the second public comment period. Ms. Bonner will end each individual reading at the 3-minute mark. All public comment will be posted online for the public to view immediately following the meeting. So with that, Ms. Bonner.
Thank you. For the record, Tiana Bonner, the Public Information Officer for the CCB. So far, we just have one public comment. It's from Kim Rushton. On behalf of RadSource Technologies, Inc., RadSource, it is respectfully requested that this correspondence serve as public comment before the Cannabis Compliance Board at the September CCB meeting. In support of the comments made herein, please find attached a recently published December 2019 FDA notice announcing the repeal of a regulation that pertains to irradiation. As the CCB is well aware, cannabis is a drug, and while it's not an over-the-counter drug regulated by the FDA, it's clear that the FDA does not consider sterilization of a drug by irradiation to be a threat to the health and safety of the public. Accordingly, based on the plethora of scientific evidence previously submitted to the CCB on the specific subject, RadSource respectfully requests that the CCB a reg workshop to repeal Regulation 12.065 NRS 678A.4601D, recognizing the ability of an interested party to file a petition to accomplish said objective for the reasons set forth herein and in concert with the FDA's position relative to irradiation. RAD respectfully requests that the CCB initiate the process to repeal Regulation 12.065 as confirmation of the fact that the treatment of cannabis with irradiation is not at all dangerous. Thank you for your consideration of this request.
Thank you, Ms. Bonner. Chair, moving on to agenda item number 2. This is the approval of minutes. Chair, I'll kick it back to you.
We have under meeting minutes and A and B, consideration for approval of the August 7th, 2020 Cannabis Compliance Board meeting minutes. And we have the consideration for approval of the August 25th, 2020 Cannabis Compliance Board meeting minutes for possible action. If we can either get individual motions or a joint motion as to those 2 items for approval.
I move for the approval.
Mr. Chairman. Go ahead, Member Merritt. I think it'd be a joint motion.
Dennis, you can go ahead.
I would move for approval of the minutes as stated on the agenda dated August 7th and August 25th.
I second. Jerry Merritt for the record.
It's been moved and second. Any additional discussion or corrections? Hearing none. All in favor, please say aye.
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 None opposed.
Great, Chair. Moving on to agenda item number 3, extensions for final licensure. Chair, members of the board, agenda item number 3 is a request from CCB staff for the board to consider taking action to extend the deadline for cannabis establishments to perfect any outstanding conditional licenses to February 5th, 2022. The request is to make this date effective for all current outstanding conditional licenses encompassing all license types. For background, during licensing application periods, a cannabis establishment that was awarded a license received that license in a conditional status. That is, they would then have a period of time of up to 12 to 18 months to secure all required local approvals, pass a final inspection from the CCB before their license would be perfected and they could open for business. Contained in Regulation 5.085, adopted by the board on July 21st, is language that allows the board to extend the period of time for final inspection at its discretion. Extensions granted would be for extenuating circumstances that would prevent a cannabis establishment from receiving a final inspection. Historically, extensions have been granted for issues such as delays in local approvals, delays in construction, or delays in contract or leasing agreements, but only after the request was made in detail as to why the delay had occurred and the submission was reviewed by staff. Additionally, extensions have been granted to licensees from the 2018 retail store licensing round due to the ongoing litigation in the COVID-19 public health crisis. Most recently, as part of the settlement between the Department of Taxation and various plaintiffs from the 2018 licensing round, settling parties received a 14-month extension to February 5th, 2022 to perfect licenses awarded in 2018. The action being requested, if approved today, would allow the CCB to align current outstanding requests for extensions with those establishments who have been granted an extension, and in some cases are on their third and fourth extension. This action would effectively set a hard deadline for establishments to gain their approvals, get a final inspection, and start operating. Not only would this help CCB continue its efforts to clear the decks and create a fresh start, but will ultimately make it easier on CCB licensing staff to administer and track non-operational licenses, some of which date back to 2014. Moving forward, it would also allow the CCB to get a better understanding and more complete analysis of the industry to ensure supply and demand, both with product and facilities, are appropriately positioned to support the state and industry's needs. The length of the extension being requested today, over 16 months, should provide cannabis establishments, in most cases, more than enough time to get their business in order and move to become operational. Per Regulation 5.085, if a cannabis establishment has not received a final inspection in its allotted time, the cannabis establishment must surrender the license back to the board. This is a privileged industry. There is a limited number of licenses. So if an establishment is not currently working to become operational, then we believe it's time to surrender that license back to the board. I will note Regulation 5.085, of course, will still apply, meaning that an establishment can request an additional extension if this new deadline is approved, but they will then need to petition the board at a public meeting to explain the need for that extension. So again, the request is for the board to vote to extend until February 5th, 2022, the deadline for all licenses in a conditional status to receive final inspection and move towards operation. With that, I'm happy to answer any additional questions regarding this request for board action.
Questions or clarifications from the commission?
Mr. Chairman, this is Member Nylander. I don't have any questions or clarifications. This makes sense to me to go ahead and align these dates so it'll be easier for the staff to track these non-operating licenses. And I think that 16 months is adequate time for the industry to go ahead and bring to fruition their development plans that in some cases were actually started more than 6 years ago. So I'm prepared to support a motion to approve.
Thank you. Commissioner Merritt, any questions or concerns? Or
No, Jerry Merritt for the record. No, I do not have any questions, but I will second the motion.
we have a motion for adoption. We have a second. All in favor, please say aye.
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 Aye. Motion carries. No abstentions or objections.
Thank you, board. Moving on to agenda item number 4. This is the consent agenda. We will start with 4A, complaints. Item 4A concerns 4 complaints for disciplinary action pursuant to NRS 678A.510. The Attorney General has reviewed these violations. and has recommended proceeding with disciplinary action. I will now present the violations alleged and request the board vote to authorize the service of a complaint for disciplinary action for each licensee. As to licensee A, the complaint will allege multiple violations of NAC Chapter 453A and NAC Chapter 453D. As to licensee B, the complaint will allege one violation of NRS Chapter 678C, 3 violations of NAC Chapter 453A, and 9 violations of NAC Chapter 453D. As to licensee C, the complaint will allege one violation of NAC Chapter 453A and 8 violations of NAC Chapter 453D. And as to licensee D, the complaint will allege multiple violations of NAC Chapter 453D. Chair, I'll turn it back to you for 4A.
We've been presented with 4 items as to approval of service of complaints. If there's no questions for the director, if we can have a motion going forward as to these 4 complaints.
Mr. Chairman, this is Member Nylander. I would move for approval of agenda items 4A, 1 through 4, as listed on the agenda to move forward with service of complaint for those items.
Mr. Chair, Jerry Merritt for the record. I second.
Been moved and seconded. No additional discussion. And it meets the requirements for the Nevada revised statutes for this. All in favor, please say aye.
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 Aye. Motion's carried. We move to item B.
Great, thank you. So 4B on the consent agenda is the request for withdrawal of transfer of interest. Chair, we have Dave Staley, Chief Investigator for the CCB. He will come up to present this item at this time.
Good morning, Chair Douglas, Member Merritt.
Good morning.
Good morning, Member Nylander. For the record, I am David Staley, Chief Investigator for the CCB. I'm here to present agenda item number 4B, which consists of one request for withdrawal of TOI application 19074 by Inyo Fine Cannabis Dispensary LLC, because the parties chose to terminate their purchase agreement. I'm available to address any questions regarding this withdrawal. And with that, Chair Douglas, I return that item to you.
We have a formal request for withdrawal of the transfer of interest. We need a motion for this consent item for the withdrawal.
Mr. Chair, this is Member Nylander. Just a point of clarification. I believe Mr. Staley said Inu, but I believe it's Indus Holdings.
Yes, sir. It's
and on the agenda. Yeah, just to clarify for the record.
Thank you. You're correct. It is Indus Holdings, Inc. I'm sorry.
No worries.
Thank you. I think he was just testing to see if we were awake this morning.
I think he was too. He's done that to me before, so I'm on my game. Mr. Chairman, I didn't have any other questions or concerns. This is, I think we're going to see several of these where these transactions for business reasons fell apart and wouldn't go forward, so I have no regulatory concerns. And I would move that we grant the withdrawal of this transfer of interest item 4B as reflected on the agenda.
Mr. Chair, Jerry Merritt for the record. I second.
It's been moved and second. All in favor, please say aye.
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 Aye. Motion's carried. Takes us now to item number C under Roman numeral number 4.
For the record, David Staley, Chief Investigator. I'm here to present agenda item number 4C, which consists of 6 TOI applications. Staff requests that number 6, Green Mart of Nevada NLV LLC, be continued to the October agenda.
Let's go ahead and take that particular item first. And So they're requesting continuation till September?
Yes, sir, I am.
Okay, do we need a formal motion to go ahead and do that, or can the board just do that?
Deputy Bob?
Thank you, Director Klimas. I think that it would be best for us to have a formal motion just for clarification on the record, sir.
Okay. In light of that, we would need a motion to continue this to the September meeting.
Be the October chair, just for clarification.
Excuse me, October, yes.
Mr. Chairman, this is Member Nylander. Might I suggest that we simply refer it back to staff and not suggest a date for the meeting? Because it appears this item needs just a little more investigation. And so if we would just refer it back to the staff, then it'll come up whenever it's finished on the agenda.
Chair Douglas, I think that makes good sense to give the staff the option of putting this back on based upon them doing the homework they need to do as to decide.
Very good, Mr. Chairman. If you're prepared for a motion, I would go ahead and make one.
Unless Member Merritt has any additional comments?
I have no additional comments, and I will second. Jerry Merritt for the record.
No, we got to get a motion out there from Mr. Nylander.
Mr. Chair, I would move that with respect to item number 4C6, Green Mart of Nevada LLC, Nevada LLB LLC, that we refer this matter back to the staff for further investigation.
And Member Merritt, you second that motion?
No, I'll second. Thank you.
It's been moved and seconded to refer this matter, sub 6, back to staff. With that, all in favor, please say aye.
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 Aye. Motion's carried. The matter is referred back to staff.
Thank you, Chair.
Go back to the top and to 1, and let's go through them.
Item number 1 are the TOI applications for Inyo Fine Cannabis Dispensary LLC. TOI number 19056 requests approval for an existing shareholder, Greta Carter, to sell 4.99% of her 10% ownership in Inyo to Jeffrey Taylor. TOI number 21009 requests approval for James G. Potter to transfer his 5% ownership of Inyo to the James G. Potter Trust dated September 1st, 1978. Staff identified no areas of concern with this application, but suggests that if approved, the approval for TOI number 21009 be conditioned to require that if James G. Potter is replaced as trustee for the James G. Potter Family Trust dated September 1st, 1978, that Inyo or the trust must file a new TOI to request approval for any new trustee. I'm available for any questions, and my understanding is that representatives from Inyo are present today via Zoom to address any questions that you may have as well. With that, Chair Douglas, I turn this item back to you.
Board members have any questions?
No questions.
Hearing no questions. Since this item has a condition, I think we should take it separately so we can have a motion that also includes the condition.
Mr. Chairman, this is Member Nylander. I'm prepared to make that motion and support the application with the condition, but I'm wondering on the condition if we should place a time limit within which, if the trustee is replaced, the application shall be filed. I'm just a little bit concerned if we have conditions that where we don't have a time limit within which to meet the condition. I just don't want to have us arguing in the future about, well, you know, a year went by and you did file it, but, you know, the trustee was in place for a year and we didn't know it, or I'm just trying to avoid, I just want to throw it out as a point of consideration.
Thank you as to that. This is Chair Douglas. Staff have a recommended time period that would fit.
Chief Staley, what would be an appropriate time?
I believe 30 days would be an appropriate time, Chair Douglas.
And if the INYO folks are on, perhaps they could comment as to whether that condition would be appropriate for them with his 30-day limitation in terms of filing the replacement trustee.
Do we have a representative from Menio on Cannabis Dispensary?
They should be, Chair. It may just be a minute to unmute them for the Zoom.
Chairman, Chairman
excuse-
Nylander?
Oh,
Yes.
Sorry,
Yes.
David Goldwater representing, or Chairman Douglas, through you to Chairman Nylander and to staff, David Goldwater representing INYO. That's fine. You may want a little further clarification of the timeline when the new trustee is appointed versus if the old trustee is removed or on the demise of the former trustee. 30 days is fine. Reasonable.
Having heard that response from Inyo, any other concerns while we have, or questions while we have Mr. Goldwater?
Yes, this is Member Nylander. Mr. Goldwater, I appreciate your comments, and please don't try to promote me to chair. We have the best chair in the world right now, and I have no interest in it. But
Sorry, Member Nylander. I live in the past.
yeah. Mr. Chairman, do you want me to give the motion a try?
At this point, that makes perfectly good sense.
Okay, with respect to item number 4C1, Inyo Fine Cannabis Dispensary, I would move for approval. The approval would be conditioned to require the James G. Potter Family Trust dated September 1st, 1978, and Inyo Fine Cannabis Dispensary LLC to file a new TOI application in the event that James G. Potter is replaced as the trustee of the James G. Potter Family Trust dated September 1st, 1978. Further condition that the new application would be filed within 30 days of the replacement trustee being appointed to that position.
Thank you for that motion. Do we have a second?
Mr. Chair, Jerry Merritt for the record. I second the motion.
Moved and seconded motion for approval with the conditions so stated. All in favor, please say aye.
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 Motion's carried. Continue to number 2.
Chair Douglas, members of the board, my name is David Staley, Chief Investigator. Item number 2 is a TOI application 19049 for Solus Enterprises LLLP, in which Solus has requested approval for Leeward Nevada LLC and Corfield Group LLC to sell their Solus ownership to existing members LSP Global LLC and PMC Investments Limited. Staff identified no areas of concern with this application, and I am available for any questions, and my understanding is that Alicia Ashcraft is present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I turn this item back to you.
This is Chair Douglas, and I take it there's no special conditions that need to be attached to this.
No, sir, we have no suggested conditions.
Questions, comments by the board?
I have none.
Member Merritt?
And I have none. Mr. Chair, for the record, I will make a motion that we approve Section C, number 2 for Solus Enterprise LLP.
Thank you.
Mr. Chairman, I would second that motion.
We have a motion, we have a second by Member Nylander. All in favor, please say aye.
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 Motion carries. Move to 3.
Chair Douglas, members of the board. Item number 3 is TOI application 18067 for THC Production LLC, in which THC has requested approval for Richard Stierwalt to sell 29.74% of his 49% ownership in THC to James Grant, James Bixby, Cheryl K. Shiro Van Putten, Dominique Mason, Robert Trask, and Stephanie Magruno. THC has also requested a waiver pursuant to NCCR 5.112 of the requirements of NCCR 5.110 regarding a review of all THC owners. THC has adequately addressed the items required in NCCR 5.112 to allow the board to approve such a waiver. I'm available for any questions, and my understanding is that Richard Stierwalt is present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I turn this item back to you.
With that, the only thing that seems to be on our plate is the waiver of the 5%, and they've complied with the basic 5% requirement as to names and addresses.
Yes, sir.
Questions by other board members?
I have no questions.
I have none.
With that, can we have a motion for approval of the TOI?
Mr. Chair, Jerry Merritt for the record, make a motion to approve Section C, number 3, THC Production LLC.
Mr. Chairman, I would second the motion.
It's been moved and second for approval of transfer. All in favor, please say aye.
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 Motion's carried. That takes us to number 4.
Chair Douglas, members of the board. Item number 4 are TOI applications 18076 and 21008 for High Sierra Holistics LLC. TOI 21008 requests approval for High Sierra to purchase adult use cannabis retail license RD 665 from TRNVP 098 LLC. TOI 18076 is a withdrawal request because certain owners chose to terminate their proposed purchase agreement. I'm available for any questions, and my understanding is that Ashley Ernst is present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I return this item to you.
And as to this matter, we would have no other special conditions.
No, sir.
All right, unless there's questions or concern by other board members, we can move for a motion for approval.
Mr. Chair, Jerry Merritt for the record, I have no questions.
No question. Well, actually, Mr. Chairman, a quick question of Mr. Staley, if I may. So there's a withdrawal embedded in this. So does that withdrawal have to be taken separately, or is that for a later application?
Member Nylander, the two TOI application numbers are separate and distinct. It may be better to, I don't know that it really matters whether they're addressed individually or in conjunction with each other, as long as it's clear that the board is voting to approve or not approve the specific TOI numbers. The TOI numbers are how we track the individual applications. In this case, with High Sierra Holistics, we had 2 applications by the same applicant. So I think either approach is probably appropriate.
Member Nylander, Deputy Bala here for the record. I would just concur with what Chief Staley has said, that as long as it's clear for the record, we are permitted to proceed either manner.
So the TOI numbers, would you read those into the record then?
Yes, sir. This is the application by High Sierra Holistics LLC for a transfer of interest TOI number 21008 and a withdrawal of transfer application number 18076.
Having said
Understood.
that, Chair Douglas, if we can have a motion in either form, the maker of the motion, make their motion.
Mr. Chairman, I'll go ahead and make a motion for approval of item number 4C4 as stated on the agenda. And to clarify the motion, it's with respect to transfer of interest items number 21008 and the withdrawal contained in TOI number 18076.
We have a motion. Do we have a second?
Mr. Chair, Jerry Mayor, for the record, I second.
We have a motion and second. All in favor, please say aye.
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 Motion's been made and carried. We move to item number 5.
Chair Douglas, members of the board. Item number 5 are TOI applications 2000001 and 2000002 for Natural Medicine LLC to purchase medical and adult use cannabis retail licenses number D089 and RD089 from TerraTech Corporation. I'm available. Staff identified no areas of concern with this application. I'm available for any questions, and my understanding is that Mallory Percal and Sheba Statham are present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. There seems to be a number of questions referenced this. Excuse me. With this, there were no area of concerns
No, sir, there were
and
not.
no special conditions.
No, sir.
Any questions by our board members?
No.
I have none.
Can we have a motion, please?
Mr. Chair, Jerry Mary, for the record, I move to approve C number 5 with MedFarm LLC, D089, RD089 for Natural Medical LLC.
Mr. Chairman, I would second the motion.
We have a motion. We have a second. All in favor, please.
Aye.
Aye.
Aye. We have ayes by all three of the commission members. The motion carries. That completes item number C.
Thank you, sir.
Thank you, Chair. Moving on to agenda item 5A. This is the notice of final licensure. Chair, members of the board, this is an informational item presented as a notice to the board of establishments that have been issued their final license since the last board meeting. We have one license to note today, Nevada Organic Remedies, LLC, RD219, located at 5270 Longley Lane in Reno, Nevada, received its final inspection on August 17th, 2020, and CCB inspection agents noted no deficiencies, deeming it in regulatory compliance on August 19th, 2020. As a result, Nevada Organic Remedies, LLC was issued its final license number on August 28th, 2020. With that, I'm happy to answer any questions from the board members in regard to this informational item.
Any questions or concern in terms of this?
Mr. Chair,
Informational
Jerry Mayor,
item.
for the record, I have no questions.
Mr. Chairman, this is Member Nylander. I don't have any questions. I think it's appropriate to have this as an informational item, but I don't see any reason that we would need to ratify or acknowledge it. As it's posted on the agenda, it provides a notice of final licensure and So I think that's an appropriate way to go for these final licensure matters where the staff has to go out and do a final inspection. So I didn't have any concerns.
This is Chair Douglas. Likewise, I have no areas of concern, and this is authorized. So we will move the agenda at this time.
Thank you, Chair. Agenda item 6, we will, this is the consideration of the dispute over request for change of location between Cheyenne Medical LLC and Medipharm LLC. Chair, at the last board meeting, you asked staff counsel to request in writing a brief from both parties detailing their position and allowing for each to respond to the other. Both parties satisfied staff counsel's request, and the subsequent submissions have been provided to board members regarding the current dispute. Representatives from both parties are joined in this meeting electronically and await your further direction. So with that, Chair, I'll turn the item over to you.
All right, this is Chair Douglas for the record. We requested the parties brief, blind briefs, and any comments likewise blind. We indicated we would give them up to 15 minutes to make argument one way or the other, and then entertain questions by the board. In this case, we'll go ahead and let Cheyenne Medical LLC make their opening remarks at this time, followed by remarks from Medipharm, and then concurring remarks there.
Thank you, Chair. Just give us a minute here to unmute Cheyenne Medical.
Good morning. This is Derek Connor on behalf of Cheyenne Medical. Can everybody hear me okay?
If you could
No.
speak up just a little bit.
Is that better?
Not much.
I am speaking into my computer. I think this is about as good as I can get it from here under the circumstances.
We can hear you now fine.
Outstanding. I appreciate the opportunity to appear before you today. I wish it could be in person, but I guess that will wait for a later hearing. I would also be remiss if I did not take the opportunity to wish my loving wife a happy 17th anniversary. It's divine providence shown upon me 17 years ago today, and I am the happiest man on earth still. Now, moving on to why we are here, as you're aware, this is a dispute involving my client, Cheyenne Medical, who has requested to move their license, RD 263, to the 2975 Sammy Davis Jr. Drive property, which we've referred to as the premises in our briefs. Now, you requested that we brief 10 separate questions, and I will briefly run through those so the board is reminded of them, and for those listening at home can also understand why we are here. So the first question was, who applied for the special use permit for the premises? The answer was Silver Sage Wellness, was listed as the original applicant. Who requested the extension for the special use permit for the premises? Silver Sage Wellness was still listed as the applicant when an extension was granted. What is the current status of the special use permit for the premises with Clark County? The special use permit is currently in good standing and runs with the land. Does the special use permit presently allow any cannabis establishment to locate to the premises? Yes, the special use permit runs with the land and was not specific to a particular licensee. Does the special use permit for the premises exempt a cannabis establishment from the distancing requirements set forth in NRS 453D.210(5)(c)(3)? Why or why not? Yes, in part because the special use permit was approved before the effective date of the new distance separation requirements, and in part because of the time when my client applied for their license. Does Medipharm LLC have a legal right to use the premises? Why or why not? No, Medipharm does not have a legal right to use the premises because they do not have a lease or a purchase agreement or any other agreement in writing with the owner of the property. Does Cheyenne Medical LLC have a right to use the premises? Why or why not? Yes, Cheyenne Medical is the tenant or a designee under a valid lease agreement with the owner of the property. Does the landlord of the applicant hold the special use permit for the premises? Why? Technically, the special use permit is approved for the property and runs with the land. Should MetaPharm LLC be allowed to use a special use permit for the premises? Why or why not? MetaPharm theoretically could use a special use permit if they were able to, use the property legally, if they had a lease or a purchase agreement or something of that nature, but they don't. And should Cheyenne Medical be able to use a special use permit for the premises? Why or why not? Yes, if their change of location is approved. Now, ultimately, the parties in their briefs and their replies, from what I can tell, kind of agree with regards to the special use permit. We reached out to the county because we wanted to get a feel for how the local government felt about this. And Miss Sammy from Clark County Department of Planning, indicated, as we did in our brief, that the special use permit is still good. It is not specific to a licensee. It is limited. It must be operational by, I believe, December 6, 2021. But otherwise, if Cheyenne Medical's change of location request is approved, they will be allowed to operate at that facility as far as the Clark County is concerned. Ultimately, the dispute comes down to whether or not the restrictions of NRS 210-5C3 apply to this property. It is Cheyenne's position that they do not. Those restrictions were included in AB 533, section 216.7. They did not take effect until November of 2019. The legislature, in fact, could not change the conditions of question 2 pursuant to the Constitution of Nevada. Those restrictions did not apply retroactively, and they do not prevent Cheyenne Medical from moving its license to the property. I know that MetaPharm probably has some comments to make from their end. We also have the owner of the property here today. If the board would have any questions for them, I think we can patch them in somehow. And with that, I will turn it over to either MetaPharm or the board if you have any questions for me.
This is Chair Douglas. For the record, it would probably be important to have the owner of the property, I guess, be sworn and make representations to stay as to his position as to who has a right to his property at this time.
Give us a short minute to get him on the line. Do we have the landlord on the line unmuted?
Yes, can you hear me? Hello?
Yes, we can.
You hear me? It says we're muted.
Yes, we can.
Oh, you can? Okay, great. Yeah, I'm the landlord. I'm available for questions.
Can you please state your name for the record?
David Michael Talla.
If we can have clarification, this is Chair Douglas for the record, if we could have clarification as to your relationship to the property and who you've given any kind of right to use the property.
Yes, we've owned the property for about 5 years now. It was bought initially with the intent of moving a marijuana dispensary to the property, and we were looking for a license holder that actually had a license that could move there. There was the subsequent, I think 2018, the new applications were approved, and there was another round of licenses that were handed out. There was some litigation, and they were held up, as you know better than I do about all that. And so we've been on hold. We currently have about $800,000 invested in this building that's just been sitting empty for 5 years. The carrying cost of the property are $11,000 a month, and we currently have no tenant to occupy the space. We have a lease with Cheyenne Medical, and that was effective several months ago, maybe 3 or 4 months ago. We were in discussions with MetaPharm back in 2019 to lease the property. we never came to an understanding with them for a number of different reasons, which I can get into if you care to hear about it. But we didn't get anywhere. I have not heard from a principal from Metafarm since February about this property. So that was 8 months ago. Occasionally, their attorney would call me and talk about various things, but the deal fell apart, and I really hadn't heard anything more about it until we signed a lease with Thrive, and now they've reared their head and say, they want the property, but I already have a lease with Cheyenne Medical, and I want to proceed with them and not Metafarm.
Anything additional from members of the board to ask the owner of the property? Thank you,
Mr. Chairman, this is member Nylander, if I might ask a question.
Please do so.
Yes. So with respect to how you view the property and the way you made business decisions in respect to your property, do you believe that it's grandfathered in from the distance limitation requirements that were adopted after you purchased the property?
Yes, but there was no limitations on the property when I purchased the property, and then subsequently when I got the SUP. I'm not sure what limitations that you're referring to. Which limitations are you reciting?
The distance limitations from a non-restricted gaming location.
That restriction came into effect, I believe, in November. But I had the SUP a year or 2 years prior to that. So I was grandfathered in, and by acknowledgement from the county, they say that the SUP is, I don't know what the word is, grandfathered, but I maintain my rights to put a dispensary there because I had the SUP far in advance of that law going into effect. And the 1,500
Thank you.
does not, and the 1,500 feet does not apply to us.
Great. Thank you, Mr. Chairman.
Okay. Commissioner Merritt, any questions?
No questions.
Sir, thank you very much.
Yeah, thank you.
Counsel, anything else you wish to add at this time?
No, Your Honor, I will withhold for now.
We will then go to Metafarm.
Amber, please unmute Metafarm, and Metafarm, please announce yourself when you are unmuted.
Yes, hello. Chairman Douglas, members of the board, this is Attorney Michael Cristalli. Can you hear me?
Yes, we can.
Yes.
Thank you. Chairman, members of the board, thank you for the opportunity of presenting on behalf of Metafarm today. I will pick up where Mr. Tella left off with regard to his involvement as the landowner, and I will refer to the Sammy Davis Jr. location as the Sapphire location, as Mr. Tella is a principal of Sapphires and also a principal in the entities involved in these negotiations. I will revert back to the 2018 applications where Mr. Tella said that he was trying to get a licensee for that property going into the 2018 application process, because that's what everyone believed the application process to require, that it required a location to go along with the license application. All of the applicants during that application process believed that to be the case, but for Mr. Connor's clients, Miss Amanda Connor's clients, and we know this through the DOT litigation. And it's material for the purposes of this analysis because, again, we're in a situation where the rules seem to change as it relates to a particular licensee that's represented by Mr. Connor or Mrs. Connor in this situation. This is not necessarily a dispute with MetaPharm or Sapphire, the Sapphire property, or necessarily a dispute with Cheyenne Medical. This is about an interpretation of NRS 453D.210 5C3, specifically Assembly Bill 533 that was passed on June 1st, 2019, which amended NRS 453D.210 to preclude a marijuana establishment. And I say a marijuana establishment, members of the board, because a marijuana establishment is a licensee. A marijuana establishment is not a landowner. A marijuana establishment is not a use permit. And it prohibits them from being located within 1,500 feet of an establishment that holds a non-restricted gaming license and that existed on the date on which the application for the proposed marijuana establishment was submitted to the department. Why is that important? And certainly if it is Cheyenne Medical's interpretation that no current licensee is subject to this particular provision, we would certainly disagree, and that would be a divergence of our arguments at that particular point. We believe that current licensees are subject to this particular provision, and it does apply to current licensees. Just to kind of undermine a little bit what Mr. Tella said in regard to the negotiations in this case, I was involved from the very beginning. And in October of 2019, there was an urgency by Sapphire because they were unsuccessful in their 2018 application and did not receive a license with their licensee, which was Silver Sage Medical. Silver Sage Medical had a license in the city. They did not have a license in the county, and they were unsuccessful in getting a county license. So they had to hitch, Sapphire had to hitch their wagon to another licensee. And that's when my client was contacted by Sapphire in regard to the possibility of transferring the Desert Inn location in the county to the Sapphire location. Those discussions began in October of 2019. We've attached as exhibits the email correspondence between the principals as well as the attorneys as it relates to those negotiations. I would also make reference specifically to the communications with the principals and the attorneys in reference to the draft change of location that was submitted to them in early November in regard to transferring the DI location to the Sapphire location. Why is all this important in terms of timing? Because timing was critical. Timing was important in early November because it was critical for the landowner, Sapphire in this case, to extend its use because it was expiring, I believe, on November 6th. So they had to extend the use. Why also was the November date important? It was very important because, again, AB 533 was coming into existence, which would put the 1,500-foot restriction in place with regard to a gaming establishment. So time was of the essence to all parties, and all parties were aware of that, which is memorialized in the communications and the exhibits that have been attached. What are some of those communications and how do they evidence what we're representing as to why MetaPharm is the only licensee that is eligible for that particular location? Well, if you look specifically at Exhibit 5 of our attachment to our memorandum, you'll see a communication with Todd Vitilago and myself and some of the other principals. Why is Todd Vitilago's communications important? Because he's the architect that was engaged by the landowner in this particular case and who was involved from the very beginning and who worked directly with the county planning. In that particular email, it says, item 3, we need to show all capitals, Clark County business license transfer for retail MMJ showing the 2975 Sammy Davis Jr. address. Lorenzo will need to transfer the attached business license to 2975 Sammy Davis Jr. Drive. We need this document as well as the state of Nevada transfer of location. So in early November, when they were trying to get the extension on the use, it was critical when they were negotiating with planning to make sure that they got a licensee that was eligible for that location attached to the use. What else do we have with regard to memorializing that? Well, there's another communication from Mr. Vitalago to myself and to a principal. And that date was before the subject hearing as it related to the extension of the use. So early in November, I believe it was November 1st, the county hearing with regard to the extension on the use was going to be the 6th of November, 2019. And this particular email says, Michael and Lorenzo, I left CCPD, Clark County Planning, a couple hours ago to meet with the manager who reviews submitted applications. He will look at our TI permit application this weekend on Express so we can close out that application review and pull our TI permit. He may issue a comment letter requesting a retail state license for this location. I have the Bloom license at East DI, but if you can obtain a copy of the transfer of that license to 2975 address, I can give that document to the reviewer as it will substantiate the applicant's retail license at that address, 2975 Sammy Davis Jr. Drive. Again, those communications with the architect, while the architect is dealing with planning and while the architect is dealing with the licensee to make sure that there is a change of address of a licensee to the Sapphire location. What else do we have with regard to discussions that are material prior to the date where the use was extended or the application of AB 533 in this particular case? Numerous emails, numerous telephone calls, numerous correspondence with regard to making sure that the change of location got completed and that the county was aware of the building plans, the renderings, the permits, and continued negotiations between MetaFarm and Sapphire with regard to potential management agreements and an agreement to occupy the premises. Well, what else is important? Well, there was a meeting after the submission of the change of location for MetaFarm to the Sapphire location with principals of MetaFarm, myself, and the Department of Taxation Marijuana Division. That included Director Klimas, Steve Gilbert, Kara Cronkite. With regard to the change of location of the DI Bloom retail facility to the Sapphire location. During the course of those discussions, one of the specific areas of inquiry was the zoning issue and the distance requirement as it related to what existed at that particular time as it related to distance requirements that had to be enforced. And after discussions with the Department of Taxation and their careful consideration, an approval by the DOT was given to MetaFarm on January 10th, 2020. But let's not forget that the submission was done prior to November 23rd, 2019, prior to the application of the new regulation imposing the distance restrictions. Notwithstanding Cheyenne Medical's purported lease agreement with Sapphire, Sapphire continued to engage in negotiations with MetaFarm to negotiate the terms of the agreement through the end of July 2020. When I hear Mr. Tellis say that he hadn't had any communications with any principal from MetaFarm, I find that surprising. I have Mike Nahas on the phone, who's a principal from MetaFarm, who can memorialize the fact that he had, in fact, had communications with Sapphire. I have had communications with Sapphire in regard to continued negotiations for that property. In fact, I was contacted in late July from his in-house counsel wanting to know the status of the negotiations, wherein I again said the offer was submitted multiple times to Mr. Tello with regard to consideration, and we were waiting for his counter offer or his agreement to the terms that we presented. It wasn't until we received notification from the Attorney General that there were competing change of locations that were submitted for that particular property that we learned or understood that they actually negotiated with Cheyenne Medical and entered into a lease agreement. The thing that surprises me, though, is that the execution of that lease agreement apparently didn't occur until they received notification from the Attorney General in regard to this particular conflict. I would also make note that during the hearing at the use in front of the County Commission, Mr. Figler, who is an attorney representing the landowner in this particular case, pointed out that the applicant was dealing with other issues that are not relevant to the specific zoning request that we are making today with the state. Well, what was that? That was specifically the request to do the change of location with the state because it was imperative that a licensee was identified for that location for the purposes of not only the state and being compliant with the new regulations in terms of distance, but also in an effort to get the extension on the use. So we were very instrumental in getting their use extended into 2020, I think, now, if I'm not mistaken, or end of 2021. So prior to seeking the extension of the SUP before the Clark County Board of Commissions on November 6th, Sapphire solicited MediPharm to transfer its retail dispensary license. That's a fact. Sapphire was aware that the new distance requirements precluding a cannabis dispensary from being located within 1,500 feet of a gaming establishment would foreclose any use of its SUP and urgently pushed for MediPharm to submit its relocation request to the department prior to November 23rd, 2019. MediPharm submitted its change of location request to the department on November 21st, 2019, which had enclosed a survey establishing its compliance with the requirements of NRS 453D.210 as they existed at the time. The DOT approved MediPharm's request to transfer on January 10th, 2020. Both prior to and after the DOT's approval, MediPharm and Sapphire diligently worked together on building plans, renderings, permits, as well as negotiating the terms of the agreement. In sum, members of the board, the DOT's approval of MediPharm's change of location request must be affirmed by this board because MediPharm is grandfathered in to the Sapphire property by virtue of the date it submitted its license relocation request. Conversely, approval of Cheyenne Medical LLC's request to utilize the SUP in relocating its unincorporated Clark County license would violate Nevada law because the state cannot approve a relocation request to place a dispensary on the property within 1,500 feet of a gaming establishment submitted after November 23rd, 2019. Thank you, and I'll submit it. Mr. Nahas is available for comment if you so need to hear from him. Thank you.
Members of the commission, any questions for Mr. Costello this time? Hearing none, we will at this time move back to Cheyenne Medical. And before Cheyenne Medical goes forward, any concerns or questions they wish to have Cheyenne answer this time as they have their second shot with us. Commissioner Nylander?
Yes, Mr. Chairman. This is very different from gaming in the sense of what does a grandfather mean. Unfortunately for us, the legislature did not create any sort of bridge to clarify what landowners might do before a restriction like this went into place. As far as my read of the record, there's really not any meaningful provisions that address that. So With respect to Cheyenne, my question is, I mean, the MetaFarm's position is, if, and again, I hope I'm not misstating this, but if you did not apply for a relocation prior to the effective date of the distancing requirement, then there is no grandfather going forward. So, and I guess I'd just like to get Cheyenne's comments about that, that if you did not make your application to relocate prior to the effective date, their position is that there is no grandfather and no one could move a license within those restrictions after that effective date. That's my first question. I have a second question, Mr. Chairman, but I'll defer to however you want to
Go ahead
handle
and
that.
go ahead and state your second question this time.
Okay. So the second question is that under the NAC, let me make sure I pull up the. So it's NAC 453D.413.2. There's this requirement that we have a professional survey done in order to consider the application for relocation. And that survey could not be done, essentially, because it doesn't meet the requirements of the distancing statute. So how would we be able to move forward if that was the pleasure of the board, if we cannot get a survey done in accordance with the requirements of the regulation?
And this is Derek Connor with Cheyenne Medical. Can you guys hear me okay?
Yeah, if you'd hold off just a second before you respond to see if
Sure.
Member Merritt has any questions
No,
or
I
tag
don't.
on.
No.
This is Chair Douglas for the record, just for clarification of the first question that Mr. Member Nylander asked. Is there a distinction between the land use by the county and the provisions of the Nevada revised statutes as to mandating when the, in this case, transfer of interest request was actually made, since it appears that it was made after the change in the law governing that? And is that controlling, or is the land use controlling? At this time, you can give us your best recitation.
Good morning. This is Derek again. It's our position that that statute did not take effect until after. So when the land use was approved, we believe that is controlling. The land use was approved prior to the enaction of Section 216 of AB 533. We also believe that, that if you were to rule that you could not submit the survey along with the change of location request at this time, that would essentially destroy the grandfathering clause. And the reason is nobody could ever move to one of these prior existing locations because they could not include that survey. I find it hard to believe that that would have been the intent of the legislature, and I agree with Commissioner Nylander. I mean, I think the record is unclear, and I think the law is actually about as clear as mud. The NRS 453-210 on its own refers to new applications for marijuana licenses. It does not refer to change of locations. I think a distinction should be drawn there. Now, if we were to agree with MetaFarm's position, then again, if you had a dispensary that was located within, say, 1,200 feet of a non-restricted gaming license, and that dispensary were to go out of business, decide to move, or to have their, God forbid, their license revoked by the CCB, nobody else could move to that property. That landlord, like Mr. Tall, will be left with a property that they've put in expensive tenant improvements. They've incurred cost going through and getting a special use permit. You've essentially told them, and you've destroyed the will of the legislature here and said, no, that property is no longer grandfathered. And we don't believe that that's appropriate. And henceforth is why we believe that Cheyenne Medical should have their request to move approved. And if there are any other questions, I'd be happy to address those at this time. But I kind of think that is the heart of this dispute between the two parties.
This is Chair Douglas for the record. It's an interesting proposition. We're dealing with a piece of property that never had a licensed business, reference cannabis, in place prior to these requests with the planning department and the request with the tax or cannabis compliance board. So we had no existing use, so to speak, of the property, even though there was a building there. It is a question of the county did issue the right to use the property for marijuana, cannabis, and gave a cutoff date that something had to be done by a certain date. However, there is or was, and we need to go back and check the existing revised statutes as to the point of, as you're arguing, the licensee, even on a TOI, is it from the date of the application? Application not just for the original license, but application when they're moving from one location to another. And this is distinct because it's not taking over where an existing business was situated. So those are things that we have to take into consideration. If you want to give us a final point as to that, the conflict between the zoning and the overall intent of the state legislature and their position about date of application, if you think there's a distinction or not a distinction, give you one more shot at this point before I hear from the other side.
I think my final point would be that the legislature clearly intended, whether it's because their hands were tied by the Constitution of Nevada, but there was a clear intent here to grandfather certain properties. And I think that they were grandfathering properties that were in existence prior to this. And a marijuana establishment was approved by Clark County for the premises. A license had not been approved there yet, but the county, the local government, said that they would allow a licensed establishment to be there. And they still would allow one to be there, so long as it's built within the time frame that they've put forth. So
licensed establishment. To my recollection, there was no licensed establishment on those premises. There was a request to use the land for a particular purpose in the county.
That's correct, Your Honor. And that is what the county has approved, is that it would be approved for a marijuana retail store.
All right. At this point, we will go back to MetaPharm LLC for their final comments.
Thank you, Chairman Douglas, members of the board. I would refocus your attention again to NRS 453D.210.5C3. That's what we're talking about in this particular case. To believe Mr. Connor's position would be to mean that this particular provision in the regulation doesn't apply to any current licensee. It just applies to some innocuous licensee that may get a license sometime in the future under some type of new application process. That is a ridiculous analysis. This is specific to marijuana establishment licensees. That's what governs this particular regulation governs licensees. That particular regulation came into effect November 23rd of 2019. Our application for a change location was filed on November 21st, 2019, before the change in the regulation. That's the issue. Not to mention the fact that the county, through the course of the discussions with the architect, required a licensee for the purpose of the extension on the use. That was us. So we were used not only for the purpose of the extension on the use, but also to make sure that there was a licensee in place before the November deadline with regard to the imposition of the new distance restrictions. That's the reality. That's why the dates are so important. That's why the communications between the parties leading up to the imposition of the new distance restrictions are so critical in terms of this analysis. To think that this particular provision in the regulations doesn't apply to current licensees would be an analysis that belies reason. And I've urged this commission not, again, to fall in to a ploy to change the regulations for the convenience of some of these licensees. I'd submitted on that.
For the record.
Oh,
Mr.
by the way,
Casale,
one final point. MetaFarm did in fact receive, or there was a survey there was in fact a survey submitted by MetaFarm in regard to the change of location and the use with regard to our application.
And for the record, Mr. Casale, as you've argued as to your meeting requirements, the one requirement that you are missing is having the permission of the landowner. Is that correct?
No, I believe we had the permission of landowner at the time of filing the change of location, because they were given a copy of the form that was filed to the state as it related to changing the Desert Inn retail facility Bloom to their location. They were given that for review, edit, and revisions before it was submitted to the state.
This is.
We do not have a lease.
All right. Any additional questions by any of our commissioners?
Not for me.
None for me, Mr. Chairman.
Unless there's additional questions that any of the commissioners wish to ask either one of the applicants in this particular position, I would make a motion in this matter. I would make a motion to continue this matter to our October board meeting, to allow our attorneys to take a look at what has been offered in oral argument supplementing written briefing, and whether or not we have any additional questions or concerns. This is a unique matter.
No.
But that would be the sum and substance of the motion. Continue this till October to give us a chance to look at the legal ramifications of this particular item.
Mr. Chairman, this is Member Nylander. I would second your motion. I'm in agreement with procedurally how we should move forward with your comments. I feel sort of like we're dealing as a court would with a legal issue as opposed to a regulatory issue. And for a bunch of reasons, we're in this spot. But I think I would like time to consider what the Attorney General's office has to say, as well as reflect on the testimony today. So for those reasons, I would second the motion and support it.
Thank you. We have a motion to continue this matter for additional research and to bring it back on for appropriate action for the October meeting. All in favor, please say aye.
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 Motion's been made and carried, so this matter will be back on in October. Moving to item number 7.
Thank you, Chair. Item number 7 is the next meeting date, which is October 20th, 2020. Informational on the item.
Moving to item number 8, items for future agendas or discussion only.
Chair, for item number 8, if you, Chair, or any members of the board have any items for future agenda, please let us know.
Hearing nothing, we will move to public comment, additional public comment.
Great, thank you. I believe we received one additional public comment. So, Ms. Bonner, if you would please read that public comment into the record.
Thank you. For the record, Tiana Bonner, CCB PIO. MetaFarm 1, and MetaFarm 3 LLCs have been operating licensed marijuana facilities in Nevada since the state commenced medical marijuana program. During that time, our entities have appreciated the collaboration, willingness to engage, and patience the state has shown us in the cannabis industry. Our primary focus to date has been on meeting and operating fully compliant and exceptional medical and retail facilities and ensuring compliant, patient, and customer-focused commercial facilities. Please accept this letter regarding the transfer of interest to Natural Medicine LLC for the dual dispensary licensed facility from MetaFarm LLC doing business as Green. The dispensary is located at 3650 South Decatur Boulevard, number 7, Las Vegas, Nevada 89109, and they include the certificate and adult use license numbers. Metafarm 1, and Metafarm 3 LLC has had the privilege to grow in the Nevada marketplace and be a part of the development of the cannabis industry. And by the way, this was submitted by Michael Nahas.
Thank you. Ms. Bonner? So Chair, I'll turn it back to you for agenda item number 10, adjournment.
Do we have a motion to adjourn?
Motion to adjourn?
We are adjourned.